Hi, welcome once again to The World According to George M. And tonight or today, depending what time it is where you're listening to this podcast, we have once again with us our attorney extraordinaire, Randy Neal, who is presently the Bonneville County prosecuting attorney in Bonneville County, Idaho. But he has also worked in private practice as defense counsel prior to being elected to his present position. Additionally, he has been a federal prosecutor, and prior to becoming an attorney, was in law enforcement for how many years, Randy?
18 years.
So you have a perspective of the law from many angles, and that's a good thing. Tonight, we're going to talk a little bit about the evolution of technology in trials and how that has affected the defense counsel, the prosecution, and also, why not, the jurors, because it seems as if expectations have changed as technology has evolved. We can go back to the days of, going back to October 1995, and the famous phrase, if it doesn't fit, you must acquit.
Yeah.
And theatrics. And that was probably one of the first times that DNA really played a part in a major trial. Barry Scheck, who, of course, is the founder of the Innocence Project, brought all kinds of DNA evidence, which, from my perspective back then, appeared to overwhelm the jury because he was so highly technical. What are your recollections of that trial, specifically as it pertains to the DNA testimony?
Yeah, I think that the difference in the technology from at that time period in the late 90s and then what we have now, 15 years after, from about 15 years and beyond, there's a much higher degree of accuracy, and we do see DNA technology continue to progress. I don't know how many of your listeners, your viewers, have used this Ancestry.com or the 23andMe, but there's it seems like they update your lineage every few months, and it changes just a little bit as the technology continues to progress. But I think it was a little bit overwhelming to the jury because it was fairly new. And so how that played out and what effect that made on the jury, is anybody's guess. I think there was as much politics, culture, and other factors into that decision that the jury made. But it was certainly an introduction on a very, very widely viewed platform. That was around the birth of CNN and where Court TV and where people really began to be a part of these major cases and get exposed to these new technologies.
Forensic evidence gathering has evolved so much since that time as well, because currently we have so many more tools at the disposal of law enforcement, and why not, even defense attorneys who can afford to bring expert witnesses who are well acquainted with this technology. Recently, there was a case here in Idaho where, and we'll mention the name of the case because it was national news, the Lori Vallow Daybell case. It was amazing to find out how accurately the prosecution could pinpoint the location of different individuals utilizing cellular technology, geolocation.
Geofencing, yeah.
What is the correct term?
Geofencing.
Geofencing.
Yeah.
And that played, I think, a key role in placing people in places that they could not refute as not having been there. What, other than this type of technology, have you seen evolve since 1995? We're almost 30 years from that date.
Yeah, it reminds me of another case that was part of the Serial podcast. Adnan, what was his name? Adnan, but out of Baltimore. And that was one of those cases where they first began using cell towers to kind of try to pinpoint somebody's location. But in those days, because they were using pings off of the cell towers, then they could only tell locations when the phone was in use. So anytime they started calling, it would hit a cell tower. The cell tower would record who's coming into their cell tower. And we probably saw some controversy about how accurate that was. And so, I think we're at the point in his case where he got released. And it's gone back and forth so many times, I'm not even sure what his situation is. But geofencing actually works off the GPS on your phone. And so with the smartphone technology that constantly keeps track of where you are, geofencing now is possible even if you're not using your phone. It's just based on the providers and so forth knowing your location. So
it was interesting also during the Vallow case that it was revealed that even if you use a burner phone,
yeah,
which people assume gives you a certain degree of anonymity,
yeah,
it's not really there. They knew what sites had been visited through those phones, where they had been, who the phone really belonged to, or the subscriber attached to that phone.
And I hope the take-home message is it's hard to get away with murder. So, George, I don't want you giving any, hints on how to get away with murder, right? So
that's a different program on a television network.
But yeah, we are seeing that our phones are recording all kinds of data, and there's a variety of ways now between downloading your phone and also this geofencing now that we can see where people have been just based on the fact that they have their phone or a phone that can be tracked and used. So, and they can actually start with a location and then see who was in the area by checking the GPS, what's coming in on the GPS. And so at that point, you start seeing who's driving by in the area. So we have actually used that here in Bonneville County as well to kind of pinpoint some suspects in some very serious crimes. But this case that you're talking about, is my understanding, they actually involved the FBI and some probably some pretty advanced techniques. But even now in a county that's as big as Bonneville, we're the fourth largest in Idaho. We're starting to see that technology be available to our law enforcement. But that may not be every county, not every law enforcement agency. Here, the county sheriff and the Idaho Falls Police Department, those folks are keeping up, and it's expensive. It's expensive software. It's a cumbersome process if we have to get it from providers. And so you have to be set up for that. And so some of the smaller counties that are going to see major cases may have to rely on what they can do after the fact. But that information is being collected and it's being stored. And so when you have a major case, even in a small county, the right agency can come in and help.
I think that one of the differences between the Vallow trial and O.J. Simpson is that everyone in the courtroom during the Vallow case, the Vallow trial, was familiar with the technology. It's no longer an abstract thing. It's not, well, a scientist is going to talk to us for 3 hours about DNA strands. They're going, well, you have a phone, just like the one that everyone else has in his or her pocket. We know how cellular technology works. We know how social media can track our preferences on the searches that we, when we're looking for something in particular on the web. So I think that
and photo metadata, when you
right,
take a photo, you're also capturing a lot of information that can be taken off that photo file. In the time of OJ, I think if we were going to digital, it was a fairly new thing. It was, probably still, I don't remember what the technology was like in the 90s, but we're so used to now using digital photography, and that can be associated with GPS, and it can have metadata that we can rely upon to say, when he took this picture, we know exactly where he was standing.
the other thing is that as a prosecutor, you don't need to bring a cadre of scientists.
Right.
They are
Right.
now more specialized law enforcement assets that can interpret what the electronic devices are recording, whether it be through GPS, metadata, or
Right.
anything like that. And the explanation is much more, is much easier
Yeah.
for the average person to digest and put in context.
Yeah. We just had a recent murder trial where we brought in the scientists from the state lab, and we didn't spend any time explaining what DNA was. So they were certainly prepared, and they wanted to, but it was as simple as putting the scientist on and saying, did this match? And they said yes. Basically they may have given a 1 in a gagillion or whatever the numbers are, but what we could do today, as compared to what they had to do in the O.J. Simpson trial, which they had these people explaining every various part of the technology and the theory and the science of these strands and et cetera. We don't do that today because, the DNA match is about as common as saying we match the fingerprints. People understand that. They don't need to have explanation of whorls and whatever deltas or whatever that were in the fingerprints that we used to talk about. If a scientist gets up and says, yeah, I looked at it and they were the same fingerprints, okay, we know that fingerprints are very unique and individual. And it's the same thing now with some of this technology. People were, if we went into detail, the jury would be just shutting down. They wouldn't even be listening. All they want to hear is, does it match? And now there's an understanding in the community and society that DNA can be matched, just like a fingerprint.
As a prosecutor, does it concern you that perhaps an average jury may have expectations that are not realistic? They may think
Right.
that, hey, a trial should be processed in 3 days because CSI does it in 28 minutes.
Yeah, you said the magic term there. They actually called it the CSI Effect, which when that TV show came out, then we did see an effect on jurors who kind of expected that you could, bring in that blue light and the orange glasses, and then you put it into the computer, and 15 minutes later, your bad guy's in custody. And so the expectation was, in fact, I remember a trial kind of early on when CSI was first coming out, where we had a law enforcement officer who stayed on the jury. To our surprise, we thought the defense would kick him off for sure, but he was he was with kind of a unique law enforcement agency, and I won't mention it. But anyway, he convinced the jury that we had made a mistake by not fingerprinting a public restroom in a store that was a major volume store, bookstore in the mall. And so the idea of fingerprinting a public restroom that's being used by, scores of people and probably just in a day, and then trying to match fingerprints is just very unrealistic. And yet it came from a law enforcement officer from a department that probably just didn't deal a lot with fingerprints. In fact, the technology from that time period, fingerprints were the golden standard. We hardly see fingerprints at all now. It's something that a lot of agencies don't even try to look at. But there is sometimes the expectation, well, you've got a gun and now there's a dispute over whether this person used that gun or not. Did you check for fingerprints? And because of various environmental conditions, that may be entirely unrealistic. But we are now the touch DNA, which is something that's a newer technology, is where we're seeing a lot of work being done. And so we were, in this recent trial, able to show that items belong to the suspect because of touch DNA, just remnant touch DNA. So yeah, we're in a time period both where you have that double-edged sword where maybe they expect that you would be able to do things that you may not be able to do. Like there's no just one big government computer that we all go to and let's go look in their bank accounts, and that pops up. I see that on the TV shows all the time. In fact, many law enforcement agency computers don't communicate with each other, let alone can we delve into, can we look into CCTV cameras, in a department store from the police station or something like that. But yeah, we have a lot of technology that does make it easier. So we do have a lot of video in our world today, and it comes from CCTV. It comes from people with their phones. It's just it wasn't just plain luck that we had a shooting that was caught on multiple, in fact, cameras that have been set up by businesses. And you see in the news where, people are taking videos of crimes in progress. And that is statistically becoming more and more likely that and body-worn cameras and dash cams. It is becoming statistically a lot more likely that we're going to catch things on video that the jurors can actually watch. Now, the interpretation of those videos, that's where it gets tricky.
Don't you think that there's also a bit of a presumption against police when the body cams don't work? Oh, it must have been purposely done.
Well, you bring up another issue that's related to juries, which is, in my background, so I began prosecuting shortly after getting out of law school. And that was I left the county prosecutor's office about 15 years ago. So I had that experience being in front of juries and doing a lot of trials during that time period, which was, the early 2000s. And now we're doing jury trials in 2023. And I think that in Idaho, especially, there was a pretty much a presumption that the state was being honest, truthful, sincere. Their motives were pure. And, the state was seen as the ones who just had no reason to lie, no reason to fabricate, no reason to make stuff up. And so we are fighting now especially among young people, a much different atmosphere where the police are sometimes, held suspect. Our job as prosecutors is to prosecute the defendant. The defendant's job, the defense attorney's job, is to prosecute or to put on trial the police, the prosecutor, and the victim. And so, where we really had a high presumption and a high trust, we are beginning to see more scrutiny and more concern, and that's unfortunate because there's of course bad apples in all professions, but we see an extremely small group. I shouldn't say group, small number of folks that fit in that category in Eastern Idaho. So.
Well, nationally now there are two movements that I want to have you talk about. One of them is the proliferation of of a group of people who call themselves First Amendment journalists.
Right.
And they go around provoking public officials.
Right,
auditors, right. Yeah. They're not journalists. They claim to be journalists, but
Sure.
At the same time, they claim to be First Amendment auditors, and I doubt that many of them truly have an understanding of the limitations of the First Amendment or what the First Amendment really entails.
I don't know. You and I may disagree about this a little bit because what was a journalist back in the colonial days? When we think back to who was writing and who was publishing and the extent of free speech, climbing up on the soapbox and handing out your leaflet was pretty common, right? Well, now the technology is much different. I think of a journalist in modern times as being professional, right? They've gone to school, they've got a degree, they've had some training in it. But if you really think back to the days of the First Amendment, I'm not sure any of that applied. You certainly didn't have to have a degree. And
no, but I think back to the time I became involved in journalism.
Sure.
And even those old timers who did not have a college degree in journalism, because degrees in communications and journalism were not commonplace. They were more than not apprenticeships.
Right.
Even 30, 40 years ago. But you had to at least become acquainted with ethics.
The professional standards, sure.
Right, professional standards. And more importantly, you had to be accredited.
Sure. Yeah.
When I worked in television in Los Angeles, I had to go to the LAPD with a letter from the news department.
Get a media credential. Yeah, today, I don't think from a legal perspective that's required. You don't have to have professional affiliation anymore because there are so many more forms of mass communication. I mean, this is one, right? You have a podcast here that wouldn't have to be licensed, where you and I both back in the day when we were getting into radio, we had to be licensed by the FCC and we had to have that operator license. I don't even think that's required for even in the radio. Those people who have it as a position, they can get on air now and they don't have to have that radio operator's license. But especially,
but at least, and here's where you and I will perhaps not be in total agreement.
Even today, we share one mind.
But even today, there are news organizations that are still accredited.
Oh, of course, unquestionably. There's a profession.
Just having because they adhere to certain standards. All of us who worked in different national and international agencies had even style manuals, the Associated Press, for example.
Professional standards. You had to belong to a professional group.
Right. I did a podcast in Spanish not long ago with a former colleague from our days at USIA, Voice of America, And but we were talking, and the title that we came up with for that podcast was "Did Journalism Die in the 21st Century?"
It's certainly
Because
expanded.
and we came to the conclusion that there are many other media available nowadays, and most of it is legitimate. But also, there are very few safeguards to ensure the accuracy of what is being
Sure.
said and the sourcing. I remember, and then we'll get back to the law here real quick. We'll
Well,
close the
this is one
chapter
of those.
on
Yeah.
journalism. But I remember when I was sent to Haiti after the death of Papa Doc, and when Baby Doc was taking over, and my supervisor, the one who oversaw the division I was in, said, "Remember, in times of conflict, the truth is the first casualty."
Right. Sure.
So
Yeah.
anyway, and my point is that, getting back to the
Well, I don't
topic
want
at
to leave
hand,
this just just yet, George, because from a legal perspective, what is protected? Because we had an auditor come through, and one of the things about him is he was just dressed so scary. He's really suspicious, and so those kind of situations, as the prosecuting attorney that advises the county, make us have to say to our officers, how do you respond to something like that? And we basically are saying, just take a step back. They're trying to provoke you and that kind of thing. But, I have a very good friend who is in the second largest TV market in LA, who said television news is dead. And the surveys were saying that people are getting that initially were getting their news from Facebook. Now I think
now
Twitter,
it's YouTube. Now it's
yeah, YouTube
YouTube.
and
Yeah.
Twitter are taking command. And this idea of, I can see it. I don't need Walter Cronkite to interpret the news for me. I can see it. And some things, of course, that are on that social media aren't news, but they're something that are taking the form of news. And of course, radio still holds, talk radio and news, that still holds a lot of influence. And yeah, what's the accuracy? So taking that all back to what can be allowed, under the First Amendment, that that is an evolving trend where these, what we wouldn't consider professional journalists are still under the protection, if not of the freedom of the press, at least freedom of speech. And the freedom of speech can go viral and affect a lot more people than mainstream media. And so, yeah, that's another way technology is affecting the way that we do business in the courtroom, is the influence of commentators, the comments section. That it can be a very, very small group of people who kind of throw certain ideas out there, and then people read that and go, "Oh, this is the way everybody in our community thinks."
Yeah, and my point, getting back to the original point when I sidetracked this into journalism, had to do with the fact that there are a lot of individuals pontificating on what they interpret to be the correct, what they profess to be the proper interpretation of the First Amendment, of the Fourth Amendment, things that are vastly important, but not always represented in their true light. Which leads me to getting back to the beginning of our conversation. DNA issues have been raised about services that do the DNA testing for genealogical purposes
Right. Sure. Yeah.
being used as a tool to try to use extracted DNA from a suspect to try to link him to
Yeah,
a family
familial
member,
genealogical forensics,
right?
which didn't exist years ago. And
What are your thoughts? What are your thoughts?
can I tell you my brush with greatness? So we had a particular trial here in Idaho Falls that involved a young man who actually confessed 9 times in several different interviews, and there was a drive to and separate from that issue, which was the innocent project and so forth, was the idea of how do we identify this gold standard of evidence, which was there was DNA at the scene, and it wasn't matching anybody who was being identified as the suspect. And so what was happening is, okay, if this doesn't match our suspect, we must have more suspects. And so it got to a point where the room would have had a big assembly in there in order to still account for this one sample that had not been identified. And I remember I was talking to the head of the task force. So the task force was active for decades after that trial. And at the time, back in the early 2000 or 2010, 2012, somewhere around, I actually had a chance to talk to them. And at the time, I was active with my practice with my own investigators, and we did private investigations and so forth. And we were just discussing, how would we go about identifying that DNA, because that you don't get that all the time. That's the gold standard for identifying an unknown subject. And I said, what I would do is I would start with the community, the neighborhood at the time, and then I would get samples from whoever's living there, family samples, whatever it is, and then I would start a account on Ancestry, and I would see if it would match. And it was a week later that the task force asked for a search warrant for Ancestry.com, which was probably the first one that really had been tried. And of course, the ACLU and everybody,
Sure, yeah. Unreasonable search and seizure was the cry of
privacy,
the day.
I sent my
Right.
sample there, blah, blah, blah. Do they have to provide this pursuant to a search warrant, whatever? But then that led to the scientific developments of what they're calling forensic genetics or genetic forensics, and eventually did resolve that crime. And in fact, found somebody who was across the street at the time of the murder. So that's another example of an evolving science that wasn't there 10 years ago, where we are seeing now that the law is requiring DNA samples be put into a law enforcement database, so we get away from those privacy issues and start using especially if you're a felon, but even if you have a felony, a felon who's given a DNA sample, the genetic forensics really is going to look at much larger genetic, what would you call it? Not systems, but collections of DNA and family DNA. But you really have to have a pretty big case to start using that kind of technology. And so in 15 years, are we going to see a situation where we collect DNA, put it in the computer, and then it'll pop out a family connection? Again, that's a real possibility. It just isn't making it to the small departments and small investigators, that don't have that kind of resource. But in 15 years, it could easily be there.
Following up on the fact that jurors come to trial now with a much greater knowledge of technology, is it much more likely nowadays to perhaps see someone who's not quite as informed as he or she should be hijack a jury. Can you explain what hijacking a jury is, and
Yeah.
how is that possibly a threat to an equitable resolution or outcome in a trial?
Yeah, so the jury process is we will collect 60 people. They will be summoned in. I say 60, sometimes as high as 90, sometimes in a major case, significantly more. They may be given a questionnaire, and then they come into a room. But the two major sources for that are the election rolls and the driver's licenses. So if you have a driver's license or you vote, you've registered to vote, you're subject to this random call to be a juror. And so the 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 voir dire process, which is the very first thing that happens in a jury trial, is we select, perhaps 20 or 30 of those folks to come forward and answer questions for, a couple of hours usually. And we try to root out those folks that are going to cause us trouble, or the defense will do the same thing on their side. And probably the number one thing that we're looking for is personality traits. If you ask somebody if they have a bias towards the police or towards a defendant, most people will say, I feel like I can be fair. The bigger issue is, are you going to hijack that group once you get back into the jury room through your personality? If you are so strong, opinionated, aggressive in putting across your view of the world, then yeah, you could end up with, and we have a nickname for people who sit quietly and don't answer a lot of questions during voir dire. We call them jurors. If you sit there and you don't put out an opinion one way or another, well, neither side is going to dislike you, and so they don't have a reason to take you off the jury. So if you have 10 or 11 people who sat through voir dire and were quiet and reserved, and then you put on one or two people into that group who are strong-willed and demanding and those kind of character traits, well, very easily they can kind of coerce the remainder of the jury to go along just so they can get done and get out of there.
And sometimes it's ego. You and I were talking yesterday before we prepare for this recording about a personal experience I had on a civil matter where there was a young juror who felt that I'm trying to be delicate, but who attempted to persuade everyone else that it had to be her way because she understood things, that one of those situations where I am right, everybody else is wrong.
12 angry,
And,
yeah, 12 angry.
yeah, 12 angry. And at one point she said, civil matter, we have a hung jury, and she said it proudly.
Like here's one vote that was going to hang it. Yeah.
Yeah, and we said, well, it doesn't quite work
in
that
my
way.
world,
But
that is how it works. So that's a concern. If you do hit that, but we have, for whatever reason, Idaho has a very, very small number of hung juries, it seems. And again, that can be personality driven. If you have 10 people who sat quietly through voir dire and they just don't, express their opinion, peer pressure, that first vote, and especially, it seems like many of our juries want to get done and get out. It's kind of rare we see a jury go past 8 o'clock. That's the magic bewitching hour. At 8 o'clock, they want to get a verdict and they want to get home. They don't want to come back the next day. And so this idea of, hearing these major cases across the nation where they do 3 or 4 days of jury, deliberation, that doesn't happen here much. And perhaps that's because many of our cases are kind of smaller stakes, but even at at substantial stakes. About 7 or 8 o'clock, people want to go home and see what they've been missing while they've been on jury duty. So yeah, that puts a lot of pressure, and a few personalities can really drive, and especially if there's any kind of authority where they say, I did this or I did that, or I was, I have an experience in law enforcement or science or something like that. That can be something where they're really being very persuasive to a group of people who otherwise are not very assertive. So,
well, I think this has been a wonderful conversation. I always enjoyed talking to you and getting your insights on all these things that go on every day all around us, but we only hear of the big cases, the Vallows, the upcoming trial here in Idaho of the murders in Moscow, Idaho. But there is one topic that we must talk about, but not in this podcast, in a following one. And it has to do with the topic of the sovereign citizen. It has taken deeper roots that I think anyone had anticipated. It has been around for a while, but it seems to be much more commonplace. So could we do that one in another podcast?
I think it comes from a great deal of frustration and suspicion of a government that, we're both a little longer in the tooth than maybe the greater percentage of the population as we start to drop off. But certainly back in our day, the patriotism and the trust in government and the trust that the public servants were doing the right thing just is not there. It's shocking to me that people say I don't want to do the Pledge of Allegiance. It's offensive. I cry at the thought that our younger generations are being taught to kind of reverse. On the other hand, we certainly have plenty of examples where the government has failed to live up to that public trust. And so it just has a very long-term effect. And so as people, lose that trust and their suspicion grows. But like you're saying, that's
a topic for another podcast, because we can go there for many minutes. We could go there for hours, probably.
Hey, but I think that was a good side road, because people got to hear my radio voice from my teenage years. So that's
as I said, no one overmodulates a microphone like Randolph.
No, hey, wait a minute! Did I really? Did I get too close? I should have been watching the scale.
I'll cover it with music or something. Randy, thank you so much for your expertise, for your willingness to share some time with us. I think it's always interesting getting a different perspective, as I said, about what goes on all around us almost every day, but we only hear very little of it only when you have cases that make the national headlines.
Spotlight.
So thank you again.
Well, and I'm glad that we were able to use a camera that does capture my angelic glow and my halo up there. So anybody who thought I was evil, I think that this podcast will prove that my aura is golden and bright.
Indeed, it is the power that emanates, the brain thrust.
Both of those would be quite deceiving. So,
all right. Randy, thank you again. It's been a pleasure having you with us on our podcast. Ladies and gentlemen, thank you for tuning in and following us on The World According to George M.